Hi, this is estate planning lawyer Michael Pevney. I create estate plans for families. And in this video, we are going to talk about two places to store your estate plan and one place not to store it. But before that, if you have any questions related to estate planning or you are interested in estate planning, please subscribe to this channel, like this video, and you can ask an estate planning question in the comments, and I'm often able to respond, sometimes even in a video. So, two places to store an estate plan. The first place to store it is we're going to talk about physical, the actual paper documents. Where are you going to want to put that estate plan? I always tell my clients to put it somewhere that is safe, but not too safe. Frankly, maybe I'm giving away too many secrets about my own life here, but I put mine in a folder on the upper shelf in the bedroom closet. And it's just sitting up there on the shelf. Anybody can grab it. And here's why. The information stored in those documents don't reveal much more personal information than you might even have on like a bank statement. So when I create a revocable living trust and an estate plan for my clients, I don't put their social security numbers in it. I never even know their social security numbers. They don't need to be in there. They don't need to be in an estate plan. If you want to be a little bit safer about it, you can put it in a safe. But when I say it needs to be safe, but not too safe, what I mean is that people need to be able to access it in a pinch. Obviously, if you pass away, somebody needs to know where these documents are. If it's a will has to be filed in court. If it is a trust is going to need to be shown to financial institutions. And people are going to need access to these documents. But an estate plan is not just a will or a trust. It's also a power of attorney, a financial power of attorney, and an Advance Healthcare Directive. So if you get in a car accident and the hospital needs to know what your final wishes and your final instructions are, those documents are going to need to be accessible by a spouse or a child or whoever you have appointed to be your healthcare representative or your power of attorney. So those documents need to be accessible. So if it is in a locked safe, it has to be accessible by the people who will need to access those documents. And if it's hidden in a corner on a shelf, people need to know where those documents are. The second place is that it should be scanned after it is signed and notarized. After the estate plan is signed and notarized, I always scan it, and it needs to be stored digitally. And it needs to be accessible both to you, if you need to access that, and sometimes you need to email a copy of something to a financial institution or a mortgage broker if you're refining the house and you want to take title to the name of the house. And it's always a good idea for the lawyer to retain a digital copy. I have a digital copy of all of my clients' estate plans after it's been signed and after it's been notarized in case something happens to the originals. Oftentimes, a signed, notarized digital copy can take the place of the actual originals. Sometimes it depends on the financial institution that you're dealing with. If that doesn't do and the people are still alive, we just print out the estate plan again and we sign new originals and we have them notarized and we go through it like that. So, two places to store your estate plan. Somewhere that's safe but not too safe, and digitally. Both the client and the attorney should keep that. The one place where you should not store your estate plan is a bank safe deposit box. Do not put your original estate plan in a safe deposit box, because a safe deposit box isn't really a bank account, it's more of a lease. You're actually just kind of leasing that spot. And if you are not on that lease, if the people that need to get access to those documents are not on that lease, they're not getting in there. So remember when I just spoke about a car crash and maybe somebody's in a coma and we need to get those healthcare documents to the medical professionals, to the doctors? Do you want the plug pulled? Do you want your life extended? Do you want organs donated? All of these questions are contained in that estate plan. So, is the person that's going to be making those decisions going to be able to get in that safe deposit box when they need to? First, they need to be on the named on the safe deposit box, and second, the bank needs to be open. You know how people talk about banker's hours because the bank's not open very often? The bank is open way less than half the hours of the week, and not on Sundays, weekend hours, right? So you need to be able to access those documents in a pinch when you need them. Do not put them in a safe deposit box. Heaven forbid we create a trust for the purpose of avoiding probate and court hearings so your estate can pass smoothly, but then it's in a safe deposit box and nobody can access it. That means we might actually have to start a probate case in court in order to get an order from a judge to get into that safe deposit box to reveal the trust. So the two places to put an estate plan: retain a digital copy and keep the originals in a place that's safe, but not too safe, where people know where it is, the essential people have access to it, and do not put it in a safe deposit box. If you have questions about this or anything else related to estate planning, please subscribe to this channel, make a comment in the comment sections with a question. I'm usually able to respond. And if you live in California, you can set up a time to meet with me for free by going to ocestateplanlawyer.com. Thanks for watching this video.